Okay, so you just got served with a collection notice and lawsuit. What do you do now? I'm going to tell you in the next few minutes. Hi, I'm attorney Chris Benson, and welcome to our YouTube channel, Listen to Your Lawyer. A lot of people don't know what you need to do when you first get served with a collection lawsuit, so I'm going to give you the answers. Number one, you want to make sure that you hire a lawyer for sure, but let's say you can't get into a lawyer soon enough. There's two things you need to do. Number one, you need to do a notice of appearance and answer. That just tells the court and the other attorney who's suing you who to contact, your address, your email, and your phone number. That way you're entitled to notices from the court. The other thing you have to do is you actually have to answer all of the different allegations that are in the lawsuit against you. What does matter is the form of your answer. And once again, I highly recommend that you hire a lawyer to do this because that really matters. How you answer each allegation against you, whether you are married, your address, your county of residence, the reasons why they say that you owe the money. So there's two things you need to do. One is a notice of appearance, and the other is an answer to the complaint or the petition that's been filed against you. You need to send that to the court. Now, on the lawsuit, it's going to show you at the top of the page, it's going to say the court that you're being sued in. It might be a district court, it might be small claims court, it might be a superior court. There's lots of different jurisdictions. So it's, at the top of the page, it's going to tell you the court that you need to send your answer and your notice of appearance to. It's also going to tell you the identity of the person or the entity that's suing you. So that's called the plaintiff or the petitioner. The lawsuit's also going to show the case number, and each case that is filed in a court has a unique case number. In preparing your notice of appearance and your answer, you need to make sure that you have the correct court on there. You need to have the correct case caption. That's the plaintiff or the petitioner versus you as the defendant. And you need to make sure you have the right case number as well. Now, when you file that, you need to file it with the clerk of the court for the correct county or the correct court where the lawsuit's filed. You need to provide it to the entity or the person that's suing you, and you need to provide it to their attorney. And typically in most lawsuits, in the bottom right-hand corner of the page, it's going to give you the name and the address and contact information of the law firm who's filed the lawsuit. Now, in most states, for collection notices, you only have 20 days to do a notice of appearance and an answer. If you don't do a notice of appearance and answer by the deadline, then the entity that's suing you can go forward without any other notice. And that's a really common problem that we see in our practice, is that you'll get this summons and complaint, and I'm going to show you one on the screen. And it might be one page or it might be 2 pages long. People think that, well, it's not very long, so it's not important. And that's just not true. It's a short and plain statement to lay out the allegations as to why you potentially owe the money. So make sure you do a notice of appearance and an answer by the timeline. And in the summons, it's going to tell you exactly how many days you have. So on the screen, I'm going to show you a simple summons that says it has 20 days to do a notice of appearance and answer. In your jurisdiction, it might be 30 days. In different circumstances, it might be 45 or 60 days. But the summons is going to give you the answer, who you need to send the response to, the notice of appearance and the answer, and it's going to tell you your timeline. And the time starts ticking when the lawsuit is actually served on you. A lot of people play this game where they try to avoid service because they've seen it on TV or they've seen it in a movie. I'm telling you, that's a bad move. If you know that somebody is trying to serve you with a lawsuit, make it as easy as possible for them to hand you the accurate information, because they're not going to just forget about you. The fact that you make it difficult on them doesn't mean that they're going to go away. So I recommend, if you know somebody is trying to serve you with a lawsuit, try to contact them if you know who it is, and get the copy. That way you have a complete copy. And that way you also know the day that the clock starts ticking for when you have to do the notice of appearance and answer. Like I said, if you don't do it in the right amount of time, then the other party can go get a default judgment against you and not give you any notice. That's why the pleading called the notice of appearance is so important. When you give that to the court and you give it to the other attorney, then the attorney has to give you notice of everything that they're going to do going forward. And that's where most people goof up. They don't do a notice of appearance. And if you don't do a notice of appearance, then the other side, after the 20 days has expired or the 30 days or whatever the timeline is for your jurisdiction, they can just go forward and they don't have to tell you about it at all. So what commonly happens is when you fail to appear, then they'll file a motion for default with the court. They'll get a default judgment against you. They win regardless of the facts of the case. They get whatever relief or whatever money that they're looking for. The judge will sign it, and then they wait. They might wait a month or 2 weeks, or they might wait a year. Judgments in Washington are good for 10 years, and they can be renewed for another 10. So the collection creditor can chase you around for 20 years if they want to. And then they can garnish your bank account at any time without any notice to you. And they can garnish 100% of whatever funds are in the account when they serve the garnishment. They also can serve notice of garnishment on your employer. That's typically the phone call that I get. So what we do in those cases is we do a financial analysis for the client. We find out what their options might be. And the only way you can really stop a garnishment is by filing an actual bankruptcy case with the court. That puts an automatic stay into place so that there can't be any more collection efforts. It's a way to put a stop or a freeze on creditors from taking money or jumping over other creditors, and allows you some time to organize your income and your assets and your expenses so that you can put a plan together to solve not just this one creditor who's suing you, but all of your debt together. Thank you for watching today's video on Listen to Your Lawyer. Make sure you hit the subscribe button so that you receive future notice of our videos, and also hit the like. That helps us out with the channel quite a bit, and the notification bell so that you don't miss any future videos. I'm attorney Chris Benson, and remember, always listen to your lawyer.